of Tennessee is now in session.
Good afternoon, Council. Before we start, we don't anticipate any technology-related problems, but if we have any, we'll take a pause and we'll work through that. Mr. Murphy is participating with us by telephone. So, Mr. Murphy, if you have any problems, just kind of speak up, or if you can't hear or anything, okay?
Yes, Your Honor, I will.
Clerk, call the case, please.
Michael Murphy versus Richard Sarta et al.
We'll hear from the appellant.
This is Michael Murphy representing the appellant. I'm an attorney in Morristown, Tennessee. The issue is whether court reporter costs can be awarded for hearings in addition to the deposition and the trial. The appellee rests a lot of its case on Fannin versus City of La Follette, but on page 418 of that decision, 434 rather, Justice Wade indicates that in that particular case, the hearing was for a restraining order. It was specified for a restraining order, and the justice went on to find that the party was the prevailing party. Unlike this case, the counsel for the defendant is asking for costs for 7 hearings, but nowhere in the record does he specify what those hearings are for, and nowhere in the record does it indicate that his clients were prevailing parties. As a matter of fact, they filed 3 Rule 56 motions during the case of this case, which they have drug out for about a decade now, and they lost all of those, so they certainly weren't the prevailing party. So the point is, I don't think that Justice Wade was opening up a can of worms in the Fannin case. He specifically limited that to where the counsel had indicated specifically what that hearing was for, unlike in this case, and he had also went ahead and determined that that party was a prevailing party, and none of that exists in this case. It's nowhere in the record. In addition, from a technical standpoint, the order on plaintiff motion related to discretionary costs, which is the final order awarding the costs for the hearings, indicates that is discretionary costs are being awarded pursuant to 54.02, which deals with multiple claims for relief from multiple parties and not discretionary costs. But be that as it may, the defendant's counsel did not list in the request for the 7 hearings cost what they were for, what they specified, what the purpose was, what was involved, and whether they were the prevailing party, all of which was taken care of in the Fannin case. So I think those cases are very distinguishable. In addition to the order, the final order in this case, there is no finding or determination by the trial court judge that any of these expenses requested by the defendants were reasonable and necessary. The judge just indicated that he would award court reporter related expenses. He didn't. Nowhere does he say that these expenses are reasonable and necessary. It's nowhere in the order. The defendant's counsel drew up the order. It's in the transcript, page 508. And again, there's no hearing or determination or finding, rather, that any of these costs are reasonable and necessary.
Mr. Murphy, this is Judge Davis. I want to backpedal just a second.
Sure.
I think what you said was on various motions for which the defendant obtained discretionary costs for court reporter fees, you said there's no indication that he was the prevailing party. Is it your position that he must show he is the prevailing party for every individual motion or hearing or whatever the discretionary cost is for? Or is it not the prevailing party overall, in this case, the prevailing party at trial?
Right. I understand your question. It's an excellent question. Probably until I read the Fannin case, I probably would have said if they were the prevailing party at trial, but that one specifically limited that the expenses for that hearing, and Justice Wade went into some depth to indicate that particular person, Mr. Fannin, was in fact the prevailing party in that motion for a motion in that particular motion. So if you read it literally like that, I think that you would have to go through every hearing that they're requesting expenses for, court reporter expenses for. I think you would have to go through, which does seem burdensome, and I guess that's why I'm saying I don't think that the Fannin case opened the door to every hearing, subjecting the person to court reporter cases down the road. Does that somewhat answer your question?
It does, I guess. And then my other question is, I haven't gone back and looked through the record yet to see what Mr. Ward's affidavit said and what specific discretionary costs were being awarded. But is it your position that he is asking for discretionary costs outside of what's contemplated in the plain language of the rule in 54.02, like not just court reporter fees for depositions and expert hearings, but something beyond that? And is that specifically, like, I'm not sure what I'm supposed to look for in terms of how do I know what the award was for? Is it contained in the affidavit of Mr. Ward, I guess is my question.
He in the affidavit, he just lists the hearings, which total $2,269.01, but he doesn't put anything more than that. There's no way to know what the hearings were for, if he was prevailing party in those hearings, what the substance of those hearings were, like Justice Wade had gone through in his case and indicated that was for a restraining order. He had made certain that he indicated that, kind of, I think, to tell us that it's not for every hearing. But the case Massachusetts Mutual Life Insurance Company versus Jefferson, on page 35, it says that it's the trial court's judge's role to limit the awards to costs specifically identified in the rule. Nowhere in the rule, 54.04, does it allow court reporter costs for hearings. They could have included hearings. They could have said for deposition hearings or trials, but they didn't do that. They specifically left it out, and they didn't put it in there. So it's almost asking, the defense here is almost asking the court to open a can of worms, and just because they want the extra $2,269 just to go ahead and say, well, the judge said it was court reporter related, and nothing further, not that it was reasonable, necessary, not that it's included in the rule, because it isn't. So absolutely, I am stating that it's not awardable in any aspect, despite the one limited award there in the Fannin case. I just think it would open a can of worms, and I realize that it's a double-edged sword, and I could be on the other side arguing for these, but I think the counsel for the defendants I think his affidavit is defective. It doesn't contain enough information. It doesn't specify what the hearings are for. It doesn't specify he was the prevailing party, and both of those things are required by the Fannin case.
Mr. Murphy, let me tell you, you got about 1 minute and 50 seconds.
Okay. Thank you, Judge.
Let me ask you a question about as I understand it, you're arguing that the court reporter that the trial court did not find that the expenses were reasonable and necessary. Is that correct?
The judge in the order drawn up.
Judge, I'm sorry.
Yeah, that's in the order drawn up by Mr. Ward. I've got it in my hand right now. There's nothing that says that these expenses were determined or found by the court to be reasonable and necessary. The transcript, the judge mentions he's going to award court reported related, those 3 words, expenses.
The court didn't award all the fees requested, correct?
Not the expert. He awarded everything except for the expert witness fees. That's correct.
Okay. You got a little under a minute left.
I do think I think the burden of proof is on the the moving party, the defendant, and his affidavit, I think, is defective in that sense that it doesn't contain, what it should, according to everything that's been indicated in the Duran versus Hyundai case. That case specifically says that the party that's filing it has the burden to show that they're not engaged in conduct during the litigation that would justify depriving it of the cost it is requesting concerning the bad faith. So there was no proof put on that they did not engage in bad faith, and according to the Duran case, the burden is on them to do so. So I'll turn it over to Mr. Ward.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Thank you.
You need to unmute.
Your Honors, thank you. This is Kenneth Ward for the appellees in this matter. Very briefly, Your Honors, the court did exercise its discretion properly in this case. As Judge Sweeney noted, my affidavit had asked for, and our motion had asked for, approximately $8,400 in discretionary costs, which included our expert fees at trial. As the court knows, some trial judges around the state do award those, some do not, which is part of the exercise of discretion. In this case, Judge Pearson declined and had a total for the discretionary costs that he awarded that were the court reporter fees for pretrial hearings and for attendance at trial. And what he awarded for the attendance.
Sorry to interrupt you so early, Mr. Ward, but that was going to be my question is, are some of these discretionary costs awarded not for court reporters associated with deposition and trials, but for hearings? And if so, that is not contemplated by the rule, is it?
Your Honor, I don't believe that. Well, let me back up and answer your question first. Yes, some of the court reporter expenses that Judge Pearson awarded were for hearing attendance pre-trial. And I would submit to the court two things in that regard. First of all, this was at the least a hotly contested litigation. And the reason that we had the number of hearings that we had is because in large part of an inability to work out agreements between counsel. It was not an agreeable course of litigation, and that's okay. I've been down that road before, and so has the court. But secondly, the issues raised by the plaintiff in their appeal were available to them during the process that the court went through in determining whether or not to award discretionary costs. And the main focus of the appellant's argument and briefing during that time were the purported allegations of how poorly I treated the plaintiff during the trial of the case and the bad faith issues. The issues raised today and in the plaintiff's brief were never brought before the trial court's attention. Whether or not the order contained reasonable findings that they were reasonable and necessary. My affidavit stated that they were, and the order was entered based upon the affidavit and the record as a whole. We are not required under the Tennessee rules to put on additional proof that the amounts are reasonable and necessary. In other words, I didn't have to bring a court reporter to trial to determine, or to a hearing to determine whether or not those items were reasonable and customary. Judge Pearson made his decision. He actually made a math error the first time, and Mr. Murphy correctly pointed that out, and we had to go back, and there was a second opportunity for Mr. Murphy to raise the issues that he is talking about today, and he neglected to do so. So my position is that those items and those arguments are waived. I don't agree with him with the reading of the Fannin Court. If Judge Wade had specifically said or specifically desired that the rule of law be that the only way to be awarded discretionary costs on pretrial motions is for a specific finding to be that the prevailing party at trial was the prevailing party at the hearing, then I believe with his jurisprudential background and his experience on the bench, he would have said so, but he didn't. and I don't think that's a requirement under Rule 54. The court has to base its finding upon the affidavit of counsel related to the bills. There was no countervailing affidavit submitted. There was no statement by Mr. Murphy that any of the bills were unreasonable or unnecessary. And if there were, that might be a bit disingenuous on his part. So it's my position, Your Honors, that Judge Pearson did his job. He went through the affidavit. He went through the bills. It was not a 2-minute hearing where we showed up and he rubber stamped an affidavit and we went forward. And based upon those things, he awarded what he awarded, and we would ask the court to uphold that ruling today, particularly in light of the fact that the items raised by Mr. Murphy do not meet the level in the case law as to what is required for an abuse of discretion standard to be granted. And we've set that out in our briefing, and I do not need to belabor the court's time today on that. Your Honors, that's basically my argument. I am happy to answer any questions that the court has, but I truly believe that sometimes less is more.
So it's your position then, in answering Judge Davis's question, that Rule 54 does contemplate the award of these fees to you, even though they're pretrial fees?
I believe it does, Your Honor, and I believe the Fannin case stands for that proposition. We can talk about the Fannin case all day. I wasn't there. I didn't argue it. It's what we have to deal with, but it is the case in Tennessee that allows for pretrial type expenses such as the one in this present action to be recovered by the prevailing party at trial.
All right. I hear no additional questions. Anything else, counsel?
Nothing for me, Your Honor. Thank you very much for the opportunity.
Thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honor. I didn't waive any thing in response to Mr. Ward's statement. In the technical record, page 436, there's a response to the defendant's motion for discretionary costs, and it goes through all of the things that I have mentioned to you, and the judge obviously was aware of that, and we went over all of that. And in one of the last sentences, it states that defendant's counsel has engaged throughout this case in bad faith at every turn. So that issue was definitely before the court, and according to the Duran case, they have the burden to show that they have not engaged in conduct during the litigation that would justify depriving them of the cost they're requesting, and they did not do that. As a matter of fact, some of the bad faith things, they mentioned in their motion for costs that they were including Rule 68, that they were entitled to discretionary costs under Rule 68. They mentioned that about 3 or 4 different times in the file. It's in the transcript 483, 484, page number 5, page 3 and 4. But the thing is, they kept on and on stating that was the law, that under Rule 468 they were entitled to court reporter fees. And then in their brief to this court, they acknowledged that they knew that there was no such thing, that court reporter fees were never allowable under Rule 68. So they were not being honest with the trial court in any respect. Mr. Ward, in the trial itself, was admonished twice by the trial court judge before the jurors took their first restroom break. He was admonished for having a form showing the jury up on the screen, like a sample ballot that was in bright red, the word no for the jury form that they returned. The judge ordered him to take it down. Then, that was in his opening statement. Then after the jurors were trying to leave to take their break, very loudly he told the defendant witness in front of all the juries that you did a good job. And then his defendant, Mr. Sarta, loudly said, I just told the truth. And he was again admonished by the court. He showed up at mediation without his clients, with no agreement by anybody to do that. On the treating physician deposition, he used subterfuge and deception to keep that from my treating physician from being able to testify. He undertook a dual representation of defendant Keck in direct conflict because she had been pointing her finger at Sarta throughout the whole trial. And during the deposition, they kept me there for over 5 continuous hours waited 6 years to take the deposition, and they just completely, in my 40 years of practice, I've never seen any bad faith that would even come close to this. But I do appreciate, again, your listening to this argument, and if there's any questions, I'd be happy to answer them.
I hear none. So, of course, thanks to both counsel. We appreciate your oral arguments and your briefs in this matter.
Thank you.
Mr. Hibner, if you'll please recess court until 2:30.
Thank you,
This
Your Honor. Good to
court
see
is
you
now
all.
in recess until 2:30 p.m.
Yeah, counsel, you're free to go now.